Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, hold an indictment within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed.
Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about the case since we left yesterday? Everyone said no or should be. Is Dr. Russell in the back there?
Mr. Brennan, you can set up if you want to.
Doctor, I'll remind you, you're still under oath. Thank you.
Thank you.
Good morning, Dr. Russell.
Good morning, Your Honor.
May I?
Yes.
Good morning, Doctor.
Good morning, Mr. Brennan.
I had asked you yesterday if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes.
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who helped me or made suggestions in organizing the report, having certain sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no?
That is correct.
May I approach, Your Honor?
Yes.
May I ask a question?
Yes.
Thank you. You had testified in December 22nd, 2024 in this case?
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
Then I said, okay. And you answered?
No, I wrote the report.
And then finally I asked, who helped you with your report? What did you tell us?
I said, Mr. Lessie.
And Mr. Lessie, is that gentleman the attorney who asked questions on direct examination?
Yes.
Okay. And so did Mr. Lessie help you with your report?
What I recall is we discussed the report. But I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but, you know, you have something in writing.
Do you think you would have testified to that if it was inaccurate?
I don't. Mr. Alessi did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
Did you have any help talking about differential diagnosis?
No, I'm very familiar with differential
And
diagnosis.
so, after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, that's my recollection.
If it's your recollection, I'm happy to show you what
Yes,
you
please.
just testified to. You want to see it again?
Yes.
Okay. By the way, between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I ask you a question? Did that advice come your way?
That's my general advice from previous times.
Well, did you have any advice last night about that?
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Alessi.
So did you and Mr. Alessi, you know there's a sequestration order, don't you?
Yes.
That's a sequestration order that you're not supposed to discuss the case at all with anybody?
Well,
during the
we didn't discuss specifics.
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the sequestration order mandates that you're not supposed to speak to people, including the attorneys, about this case overnight? Did you understand that?
There were no specifics discussed.
Or did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I
order
didn't.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
There's a driver.
Okay. Who else is in the car when you left court yesterday?
The driver.
When
No, I wasn't with him yesterday, no. Not in the car yesterday, no.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out when was it that you were having conversations with Mr. Alessi relative to the sequestration order that you're under?
This morning, riding to court
Okay, so you and Attorney Alessi drove to court?
with the limo driver, yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just a sequestration order.
We did. We spoke about Boston, how I love Boston area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride back to the hotel yesterday, with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red Sox or the weather. What else did you talk to Attorney Alessi about this morning other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
about this case?
No.
I'm sorry, but I'm asking you about this case.
That was it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some there must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript. You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
Okay. What else did he tell? How did it come up? Hey, by the way, ask for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
Do you have any memory issues?
No.
May I approach?
Yes.
Transcript, page 36. Since you've asked for the transcript, I have it for you. Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but I'm going to show it to you because you asked. Take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than, you couldn't be 100% certain?
That looks consistent.
Okay. You want more time with the transcript?
No.
Has anybody else talked to you about your testimony today overnight, Dr. Russell?
No.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date?
Yes.
May I see the transcript?
Of course. Pursuant to Attorney Alessi's advice, let me approach.
Objection, Your Honor.
I'm going to strike that, disregard that, jurors.
May I approach?
Yes. What page you want us to?
23. June 21st, 2024, Doctor?
June 21st.
Page 23, line 14. Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? What did you say?
I said yes.
Thank you. Have that back?
Yes, you may.
Okay, thank you. When you gave your opinion, not this year, last year, you agreed when you were assessing the wound, you used the word, or adopted the word possibly, didn't you?
Explain the context of it?
Sure.
That sentence?
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
Then I'm sorry. Please rephrase the question.
When you were asked about your opinion last year, not this year, last year, about whether to a reasonable degree of medical certainty the injuries were from an animal attack, possibly a large dog, you agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Do you remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest there was some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes.
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you described methodology, you were asked by Attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There is no standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
So there is no source. There is no recognized community. There's no certification. There is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So, no, there's no published standards.
No published standards. There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday is a readily accepted standard in the dog bite community. You can't point to anywhere, can you?
There are peer-reviewed articles which list recommendations on how to determine something is from some wounds are from a dog. These are peer-reviewed articles written by esteemed physicians that have analyzed dog bites and have published these and have published an approach to identifying, particularly a forensic approach to identifying dog bites.
Let me ask you the question again, Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites? One article, one journal, one book. Can you point to any?
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. DeMunick and the article with the lead author of Dr. Pollack. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before I approach. Can you point to one place, one, where there is a readily accepted standard in the dog bite community for identifying dog bites?
No.
And so with no readily accepted standards in the dog bite community, no defined methodology, when you look at a photo like you do of John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites rather than relying on some type of scientific foundation. that has been published and accepted in the community.
Objection, Your Honor.
I'm going to allow that.
Isn't that fair to say, Dr. Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make, and nurse practitioners and the like, make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites here. So let's focus on dog bites, if you would, if you can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology, and since there is no accepted and approved guidelines, you are essentially simply looking at a picture, a photograph, and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the and the articles that I read. The numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
When you say coming up with a methodology, are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely wanted to be in this case. You weren't sought out. You sought the case.
That is incorrect.
And you said you had a strong interest in dogs, and that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
No, that's actually an unfair statement. I did not want to get involved. I wanted to offer my my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case. And I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions and wounds? What else before I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
No.
I would like to put up an exhibit of Mr. O'Keefe's arm, and I want to ask you some questions about it. You and I have had many conversations about Mr. O'Keefe's superficial scratches before, haven't we?
Yes.
And would you agree, looking at these, they are superficial abrasions? Do you agree with that characterization?
Yes.
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for the sense of clarity. And we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2?
Yes.
Number 3?
Yes.
4?
Yes.
5.
Which did you call
sorry,
4?
this one.
4,
5.
5, 6, maybe.
Okay. So as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that fair?
Okay.
Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe
course.
so, but I'd have to see the transcript.
Do you remember when you were first giving opinion testimony about this specific abrasion, wound number 1? Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
Yes, Your Honor.
So, do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been
an
here many
opinion-
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Generally, yes.
Okay. So let me ask you before we talk about what you said at the beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, and very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Are you saying that nails of a dog are so similar to the teeth that you can't tell the difference between them when you're looking at a wound?
I'm saying that they can cause similar-looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell the difference between teeth and claw nails of an animal when you're looking at a wound?
Individually, well, okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern in order to make some conclusions.
Well, when you first started testifying in this case, you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
No.
It wasn't until I began asking you questions and you had inconsistent answers that you've now changed from, rather than identifying individual wounds, now you're saying I can't identify individual wounds, but I can tell you in totality.
I disagree with that. I believe that in the very first time I testified, I mentioned that the overall pattern was important.
When you first testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty? You're not sure? What is the value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
That those are caused by teeth.
Teeth. Okay. When you first testified, your position was it could have been teeth or nails. That is different than saying, to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
When you first testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Do you remember when you were asked about it and you answered? You talked about that it was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder, right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Okay. Nails on a dog, oftentimes or most times, are horseshoe-shaped, aren't they?
They're generally conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently. But in general, they come to a point They're at the, you know, at the end of the paw. They come to a point, and by the way, the paws can open and close, so the distance between the nails can vary depending on how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think that the teeth in a dog are different shapes and sizes?
Oh, yes. Depending on the tooth, there's different shapes and sizes. Absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later in front of a group of people and you again iterated that this could be teeth or claw marks? That was your testimony last year. Teeth or claw marks, right?
I'm going to object to the characterization of that prior proceeding.
So just prior proceeding, folks, that's all that we need.
Did you testify at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
May I approach?
Yes.
When you first testified on June 18th, Doctor, you were asked questions trying to identify what you thought that wound was. And this is your June 18, 2024 testimony. On page 37, line 7, the questions begin, and you were asked what you thought they were. You can read any part you want, but line 7 might be a starting point.
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
Dr. Russell, I'm just going to ask you to keep your voice up, okay?
Okay. Let me see.
Thank you. That was your first testimony last year, yes?
Yes.
Okay. And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report?
Yes.
After your consultations, do you remember changing that opinion regarding number one? Do you remember changing that opinion?
No.
Do you remember changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
No.
Are there different types of teeth in a dog?
Yes.
Okay. The pointy teeth, the big ones, those are called canines.
Correct.
And the smaller ones are incisors.
Correct.
There are 6 incisors in a healthy dog on the top and bottom between the canines.
Correct.
Okay. Did you, when you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth, and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
You had never said that the canines caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
And so after you did the report, you shifted from teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes,
That would be a mistaken use of the word.
I believe so.
When you testified, December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information about photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times and challenged, and each time I reviewed the case, I became more certain that these were from canine teeth. And actually, there's other marks there, but these are from teeth.
You say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth. Canines are some of the teeth.
Upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom, and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there, and the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
I'm going to allow.
Do you remember that conversation? You said that the point of entry would be the bigger circle, pull this way, and then I questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that at all.
Remember that conversation
No.
we had? Okay. And so, inevitably, when you look at this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound
Yes.
up there, closest, I agree, yes.
In fact, you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of these just so we're clear. Same thing with number three. You've provided opinions on this before. If you look at this wound alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
Four, same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for 5 and same for 6.
Correct.
Now, when you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could identify it as a dog bite.
I disagree with that characterization.
Number 2, what caused this wound, Dr. Russell?
Number 2, I believe that was dog bite or scratch, but mostly I believe dog bite. And because there's a punctate, little tiny, pinpoint almost, lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty. So when you look at this wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through each of these wounds separately so we understand what you actually recognize with your methodology and what you don't. So looking at wound number 2, based on whatever methodology you've been using, are there any signs, indicators, objective criteria you can look at and tell us this is or is not a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these, overall, by the way, parallel lesions are in the same general direction. So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed. Is there anything about your methodology, something that stands out about these wounds, that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today, anyways, starts here at the bottom and goes up. Is that your position today?
That's not what I said. I said the exact opposite.
So it starts here and comes down.
Correct.
Okay. And these 2 scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
I didn't say that these were caused by canines. And spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting that these these 2 linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified last year on June 18th, you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You've shared with us now you have improved your study and have new opinions. Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently, Mr.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
When you testified at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
No, I'm going to object to the word that was used and has been done before.
Mr. Brennan, word it differently.
Sorry?
Word it differently.
Okay. Did you testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
May I
Can
approach?
you just hold 1 second? Could you please turn the fan off, Paul? Jurors, is it okay if we turn the fan off so we can hear better? Thank you very much, Officer DeLong.
May I approach?
Yes.
From your December hearing, page 100, line 5, when you were asked about that second wound in December, and I asked whether you changed your opinion from teeth or claws to just teeth, weren't you asked specifically about that on page 100, line 5?
Yes. But may I read it?
Sure, I'll read it with you.
Okay. I said, I'm not sure on the second set. So this is the set just above the elbow.
I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent incisor tooth. But I'm not sure on the second set, so this is the set just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set
Yes.
up there close to the shoulder, and then the sentence, but I'm not sure on the second set, so this is the set that's just above the elbow. I said I'm not sure.
And then, sorry,
Oh, go ahead.
Are you done?
Oh. Yeah, actually, I did make another comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So, this mark was an upper tooth. This is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here and this mark here. So it appears that this is from upper, and these are from lower. That's what I was referring to.
And so when you first described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth. Correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter-of-factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believed.
And today you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You
Yes.
were asked, what do you think? And you didn't say, well, not 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
What tooth do you think caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog teeth?
Excuse me?
Do you think there's any way these two could be caused by dog teeth if you're saying that these two are caused by dog teeth?
Yes, could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't
It's
it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing, Dr. Russell.
Did you say strike or strike?
Strike with a K.
Look at the spacing, Dr. Russell.
Mm-hmm.
A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy part
That's
of the arm?
exactly what I'm asking. It's a question I've asked before. When you look at the other side of Mr. O'Keefe's arm, did you notice anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement dog or a domestic dog, you know it's like a lever, a dog's mouth, isn't it?
It can be if both jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes and coincidentally every single one of them lacks any wound to the underside of his arm?
Yes.
Your claim is that a dog penetrated the sweater on the top, but the lower jaw did not leave any wounds?
I'm claiming that that's not what I'm claiming. No. As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical opinions. Your medical opinions. Do you have any evidence that the dog's lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But yes, I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell us to a reasonable degree of medical certainty whether or not this was caused by a tooth?
Yes, Your Honor.
We're going to strike the first part. Why don't you ask the other part?
Can you tell us to a reasonable degree of medical certainty whether this superficial abrasion, put that back up please, was caused by a dog?
In and of itself, that part only, no.
Can you tell us anywhere on Mr. O'Keefe's arm to a reasonable degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds, again, is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be
Well, you have the
specific.
opinion today, and I'm getting the transcript for you, Dr. Russell.
Thank you.
You have the opinion today that that those were either teeth or claws?
Yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. To a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
So I'll strike the comment.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
Did you ever change your mind about the source of these abrasions?
Can you be more specific?
Did you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
The one near the wrist, you had testified yesterday, there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's two linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claimed, you think different teeth other than the canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside.
First of all, I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends. It depresses. So you could have two prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement between the two can be slightly different depending on the elasticity of the skin and the underlying structures.
This is not a slight difference, Dr. Russell, is it?
Again,
Objection, Your Honor.
So there was a question with that, so I'm going to let that in.
Again, Dr. Russell, the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by two canine teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes.
What did you come up with?
Visually, and I can see that there's a difference.
What was your measurement for this one?
I think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I did
measure
not.
them? Did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that process during your methodology?
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper, or report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is, it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, Doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with the car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition methodologies.
If you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
Yes. I don't know how to answer that.
Well, try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually, I disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with, and that forms a basis for me.
Do you really think?
I'm sorry, please.
Did you finish that answer, Dr.?
No.
Did I cut you off?
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis, to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case?
Yes.
I didn't have a lot of information, that's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit-and-run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of accident
yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction.
No.
Do you know what ACTAR is?
ACTAR?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
No, and I don't know any physicians that are.
Have you ever gone to a scene of a car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So, yes, I am very comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors,
Have
yes.
you studied that before
Studied.
you gave this opinion? Yes. Did you go and actually look at the photos, do any measurements before you came up with this opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at
And
photographs.
when you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight? Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the break was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see that it matched up height-wise perfectly?
Close, yes.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I have some understanding of the allegations of a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on January 29, 2022 at about 12:32 a.m., right around the time that you think these wounds happened?
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
Several inches.
Where did you get the information that there were several inches of snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you get that information from?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I saw a picture.
Okay. Not 2 inches of snow. The ground, the cold, hard ground. Did you see anything that said that?
Yes, I saw an area of grass in the picture.
Have you ever looked at Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grouse on the pants.
Did you ever actually look at
I
the
don't.
pants?
I don't know if I looked at the pants. To
When you
tell
say you
the
didn't
truth.
see any evidence, are you saying you didn't look, or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pants? Photographs, the actual pants themselves. Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as possible?
So let's,
We'll come to sidelines.
Dr. Russell, before you gave your opinion to this jury, suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with the motor vehicle, did you go to the scene of 34 Fairview and look around in the corner of the yard?
I did not need to.
Did you?
No.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth or whether it was bumpy, whether there was rocks or debris in that area?
Yes.
And you went there and looked at it?
No. You asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
Did you know that there were bushes right near the area where Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe lay?
Right where he laid, no.
How about next to him on the left? Did you see those bushes?
There was some other stuff there in the photograph, but the photographs I looked at were not of excellent quality.
Do you have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with a vehicle.
Do you know Mr. O'Keefe had other injuries other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
When you considered excluding car collision as a source of those wounds, did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where
Many.
they were
Sorry.
hit by the same car?
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people and caused a number of injuries, those injuries to different people could vary wildly from one to another?
Yes.
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
Yes.
Another person could have a less severe injury, maybe a broken bone.
Yes.
Another person in the same exact collision could have scratches.
Yes.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are there instances that you have considered where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant injuries, correct.
So a car collision can cause wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes.
When a car, a vehicle's involved, have you ever been involved in treating patients that receive injuries from broken plastic or broken glass in a car?
Yes, many times.
And when you've seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes.
When you were considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip-type event rather than being run over?
Yes, I considered multiple scenarios.
had you, or do you agree that injuries from a side swipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions, about what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios,
And when you
several different
Sorry, she needs to answer.
several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity. No significant injuries from the neck down, and so yes, I used that and tried to put that in a scenario of his various positions. What could he have been? Standing, kneeling, sitting, lying down on the ground. I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
Debris.
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell on
Did you
the
ask any
photographs.
question? I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a certain fashion to cause those regular striations.
Rather than imagining, did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer looking into car collisions, ever hear the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian, yes. Not as a medical expert.
Could I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm, were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that there was one shoe off, correct.
Were you aware that it was wedged right up against the curb? Were you aware of that?
I'm aware, I have been aware of that, yes.
And when you came to your conclusion that you offered that the injuries are not consistent with a impact or car collision, was this photograph part of your consideration?
No.
Could I have Exhibit 99D, please? In your study to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
No.
Do you see underneath that hat there was not 2 inches of snow? It looks like dirt and grass.
Yes.
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
It could be important. However, it could be. If the ground was frozen, if it wasn't frozen, it could matter a little bit.
Exhibit 73, please. When you were reaching your conclusions, you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
76A, please. Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
You can take that down, please. Would there be any significance in your study in the foundation of your opinion that a collision or impact did not cause Mr. O'Keefe's wounds on his arm? Was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken in missing pieces?
Yes.
Was it important to time when that taillight was broken?
What do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022, yes?
Yes.
Early morning hours.
Yes.
When you were making your differential diagnosis, was it important for you to learn whether around that time the defendant's taillight was broken?
It was important to know. I still don't understand the question. I'm having trouble understanding the question.
It's my fault. I'll try to ask it a different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes.
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle, yes?
That's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes.
And you learned that her right rear taillight was broken in missing pieces, yes?
Yes.
Did you want to know if there was any evidence depicting when that taillight was broken, in considering this conclusion?
Yes.
Did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
Objection, Your Honor.
I'm going to allow that.
Not at the time, but I expected that if there were a collision, that there would be pieces of the car, involved. So it didn't really make any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Ms. Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and time it?
A broken taillight in and of itself could not cause those injuries. There would have to be multiple projections from the vehicle that were lined up in a certain pattern to give those parallel marks all in the same direction. So, that's why a broken taillight could not have done that.
So in your investigation, you did not want to know when that taillight was broken?
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after.
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
And it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of a right rear taillight at about 8:03 a.m. that morning?
Would that be? I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10. It actually was from a video. Did you look at this picture during your differential diagnosis?
I think I've seen that picture before.
And
The
could we have
the vehicle parked. Yes.
Exhibit 11, please. Did you consider this picture in your differential diagnosis?
I didn't. I don't know that I ever saw this picture.
Seeing this picture, do you see that the right rear taillight is missing pieces?
I can't even see that. Oh, yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
You had, as a police officer, when you're excluding the source, and in this case you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision, do you listen to witness testimony or do you review witness statements?
Objection, Your Honor.
I'm going to allow that. Just, do you do that?
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I take witness statements?
Yes.
Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the veracity of the witness.
Have you listened to the statements of the defendant herself in this case regarding potential impact?
No. What do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact or collision in this case?
Oh, are you referring to what you've asked me previously about? Did I hit him or something of that? What do you mean specifically?
Have you seen any of the media statements by the defendant, 2020, Nightline, docuseries? Have you seen any of these statements in your analysis of whether or not there was a impact, a collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 2020 or Nightline?
I've never seen that situation.
Yeah, no. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a
You
year
know,
later, year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
Now, when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware that those clothes were swabbed for DNA traces, weren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Could we have Exhibit 147B, please? On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. Like to approach, please.
Okay, come on up. taking longer than any of us wanted to do while you're sitting here. So we're going to continue what we're doing, but we will give you the morning recess. So that's about a half an hour or so. Okay.
All rise for the court, please. Close your notebooks. Follow me.
Oh, okay. Thank you.
Sam, watch your step coming down. Follow me.
Jurors, exit the courtroom. Please be seated.
All right, Mr. Alessi, I'll hear you. Mr. Alessi, I'll hear you.
Thank you, Your Honor.
Excuse me, Mr. Brennan.
Mr. Brennan, can you remove? Oh, okay, it's being removed.
Thank you, Your Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object and object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled, under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
Okay, thank you. Mr. Brennan.
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be clear. The defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it. She discounted it. She created false theories about the potential destruction of it, but she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient. It might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday, but it is not improper. It's not unconstitutional. It's not irrelevant. It's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea that the linear, superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions to yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence, because it shows her inherent bias in all of her opinions. where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank you,
Mr.
Your Honor.
Wilson.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds of the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
I have 30 seconds.
Sure.
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 12th, 2024 transcript, I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words, we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alisi on direct examination. And there are more. There are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alisi. Wholly.
All right, thank you. We'll give everybody a half an hour.
All right.
You are unmuted.
Please be seated for the session.
All right, so the motion for mistrial is denied. Your rights are saved. And Mr. Brennan, you can continue with this line of questioning.
Nor I did not address sidebar the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could we do that outside the presence of the jury so that I don't ask the questions in front of the jury?
Yes, but not right now. They're on their way. All right. Do you have enough?
I'll work around it.
Okay.
I'll work around it.
Your Honor, I would object to being done outside the jury. That it should be done like I've had to do with several witnesses in front of the jury.
Okay. If that's what the defense wants, are you sure, Mr. Alessi?
Oh, wait, I'm sorry. Let me confer with my. Yeah. Okay. I am going to. Yes, Your Honor. We are going to.
Oh, dear.
Thank you, Your Honor.
Okay.
They're on the way, Your Honor.
Thank you.
I'll be done very quickly, so I'll have to make that decision.
Is the lunch? Are the lunches here? Probably not. Okay. Are they still over there? Have they already? We can hold the jury up now. I don't know how far along they are.
Did you start yet, or can you turn?
If they're downstairs on their way up, I don't want to stop them.
I can do it in 2 questions.
Yeah, please.
Oh. Excuse me?
They're still over this way.
Great. Okay, they're going to stay.
Your Honor, if it might help, obviously, I'll be subject to whatever Your Honor does. Based upon if Mr. Brennan only has 2 questions, I may have 30 minutes that I could, most 35, to finish up whatever redirect that I have, if that affects Your Honor's scheduling.
I just didn't want to stop them if they were on their way. They haven't yet gone downstairs.
No, I don't think they made it downstairs.
All right, we'll do this now. Okay?
Dr. Russell, during your review of the case, did the defense offer you the report of John C. Walsh, MD, Deputy Medical Examiner?
I didn't hear the whole question.
During your review, the defense provided you materials. Did they provide you the report of John C. Walsh, MD, Deputy Medical Examiner?
I don't recall.
May I approach?
May I?
Yes. Can we turn the fan off over here, Tony, please? Thank you.
Dr. Russell, did you ever review or receive that document from the defense?
Oh, yes.
And regarding Dr. Walsh's opinion, did you consider that when you formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with a dog bite?
Yes.
Did you disregard it or agree with it?
I disregard. I disagree with his assessment.
Thank you. Sorry, I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had to deal with because the witnesses disregarded it, and I was not allowed to pursue questioning. So I do not believe, under the standards that's been set in this trial, that a proper foundation has been set.
What do you say about that, Mr. Brennan? How is this any different?
Pardon me?
I'm talking to Mr. Brennan. How is this different with this witness's analysis?
Because they specifically opened the door when they had her vouch for her own credibility, extolling her uniqueness and ability to determine that these were dog bite wounds. And so when they opened their own door to vouch for their own credibility and suggested that there only person or a limited person in the entire country that can do this, they should be confronted that they are not alone. There are other experts. And so this isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these issues.
What do you say, Mr. Leslie?
Thank you, Your Honor. My response is this. I'll give 2 quick examples. Dr. Welcher, Trooper Ball, Dr. Scordy-Bello. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide that mentioned Dr. Scordy-Bello. You'll recall that slide. They even had material from the CARS team with a file named Trooper Ball.
I'm not letting it in.
Thank you.
All right, I'm not letting it in under that, Mr. Brennan. So you can mark the report if you want, but for that reason, I'm not. For the reasons stated by the Commonwealth, I'm not letting it in.
I don't need to mark it.
Okay. All right. Thank you, Hunter. An objection. Where are we? Is it in evidence now?
It's not yet. It will be.
Okay.
Could you not just say it in evidence?
The DNA. It's not, right?
It is not.
Okay.
Is there a question?
Yes, it's open. I denied the motion and allowed the line of inquiry.
Back in session, you may be seated.
Jurors, I appreciate your patience. All right, Mr. Brennan.
Thank you. Good afternoon, Dr. Russell.
Good afternoon.
Dr. Russell, we were talking about your differential diagnosis and your opinion that Mr. O'Keefe's abrasions on his arm were not consistent with impact or collision with a car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You looked on direct examination at a photograph in Dr. Welcher's presentation, and it had a photograph of a person who had been hit and died as a result of a collision. Do you remember that photograph you looked at?
The photograph of which one specifically?
There was a gentleman
I've
lying
seen.
on the ground. His face was redacted, and there was.
Oh,
some
that one. Yes.
Remember that one?
Yes.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was? What you were trying to deduce or
No, I was
suggest?
just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with a car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body breaks, do you have any studies about the frequency or the likelihood of lower body breaks in a clipping impact as opposed to being directly run over?
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body breaks?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body breaks?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed the height and the location when it touched Alexis? Did you see that?
Objection, Your Honor.
I'm going to allow that.
Yes, I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Text stream, the black box that shows the operation of a car, how fast, how slow, acceleration. Did you look at any of that information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the text stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't understand it, and I didn't know that if any of the attorneys understood it, actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, he had. My understanding is he had been in and out of that car, on many occasions, and so therefore there would be reason for either skin cells or DNA or possibly other, hair, fabric to be on that car.
So when you consider testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve, yes.
Having an interest in dogs and dog bites, certainly you're aware in your experience when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it. Excessive saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes.
And that's considered oftentimes very important trace evidence.
Yes.
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
No, are you aware of that?
Yes.
You've heard of UC Davis, haven't you?
Yes. And in reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So, yes, I am aware that there was some swabs taken at some point.
Is that gratuitous answer part of your advocacy or a part of your medical objective opinion?
Objection, Your Honor.
And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes.
UC Davis, do you understand they specialize in dog DNA?
Animal DNA, I believe.
And you also know, in giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes.
In fact, what was found was pig DNA.
That's correct.
And there's no identification where the pig DNA came from, is there?
I don't think so.
So when you saw the information, after you claimed there is a dog with John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes.
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
Yes.
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons, didn't you?
Objection, Your Honor.
So the objection sustained. Let me ask it differently.
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found, There are a number of reasons. If you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA, yes?
Yes.
You can't tell us anything based in fact. Wait,
no.
I'm sorry.
Oh, sorry.
You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, and you wonder why, and you want to know, was the test done correctly, was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with. And then, of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes.
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
Yes.
Did you know at the time Dr. Scotabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
Yes.
Did you know that claim didn't come about until over a year later?
No.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds?
Well, again, a complete investigation.
You can't tell us one step that went wrong with that DNA process, can you?
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to allow that.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please? Dr. Russell, this is a photograph.
Okay.
Dr. Russell, were you aware that very small fragments, shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass, can tear fabric?
Yes.
Would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm?
I don't believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
Do you know how Mr. O'Keefe fell to the ground and what movements his body and arm made as he fell to the ground?
Not definitely.
You don't know?
How? No.
Do you know how much distance or little distance he moved when he was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
You think, do you know where his body was found on the side of the road?
Yes.
Do you know if his body, before it rested, moved or slid on the ground?
Yes, it did.
And it's your opinion that fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
I wasn't asking about the collision. I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to ask you the question again. Are you saying to a reasonable degree of medical certainty that these fragments did not cause the superficial abrasions to John O'Keefe's right arm?
Correct.
I have no further questions.
Okay. Mr. Alessi?
Thank you, Your Honor.
Okay.
May I, Your Honor?
Yes.
Thank you. Your Honor, I would like to have published what is in evidence is 201A, and then I'm going to proceed after that with 201E.
Okay.
Dr. Russell, I have up this exhibit, and with regard to the questions of Attorney Brennan that he just asked about these alleged shards, can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear app plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right. And if Mr. Wolk, you could go back. Can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201E. With regard to this depiction, do you recognize what is in this depiction?
It looks like irregular, red-colored pieces of debris.
Thank you. And do you recognize the ruler above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So let's go back to, flip back to the next slide. Does the, what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are, again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your analysis as to the size of these pieces?
16. So those looks like they're maybe a 16th of an inch or less.
Okay, so let's go back, Mr. Wolk, one more time. So these pieces are a 16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolk, now go to Exhibit 1. Attorney Brennan asked you several questions with regard to whether those 16th of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, a 16th inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions. So these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction because many of these groupings of wounds, and if I may use the pointer, are oriented in this direction a little bit. well, anatomically, a little inferior to superior, ever so slightly this way. So they're oriented in the same way. So not only would they, those abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause those wounds?
You have to ask it differently, Mr. Wilson.
Dr. Russell, please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic, 1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Not at all.
You were asked several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each. He grouped these, I think, 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary, but the pattern is what is significant.
And on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions by Attorney Brennan, and in his questions, it was asserted that you don't have a standard, a published standard. Do you recall that questioning?
I'm going to allow it.
Do you recall the question asking whether you had a standard to reference for your methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology, you referenced studies and as part of your answer. Do you recall that discussion with Mr. Brennan?
Yes.
Do those are those studies peer-reviewed?
Yes.
And give the name, please, again, that we had gone over on direct, but give the name of the lead authors of each of those studies.
Yes. So one of them was by Dr. D. Munich, and the other one was Dr. Pollack. And by peer review, that means that it's the article was reviewed by other physicians in those respective specialties of the authors.
I'm sorry to interrupt you, Dr. Russell.
I'm sorry.
Finished?
The specialties of the authors, yes.
If we could take that down for a moment. Your Honor, may I approach, please?
Okay.
If I could have, Your Honor, for Madam Court Reporter, exhibits marked for identification P, 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 and Q, Q, Q.
Right.
And I'll start with P, P, P if I could, please. Thank you, Madam Court Reporter. May I present PPP to it? Thank you, Your Honor. Dr. Russell, you have before you PPP. Is that the study with the lead author, Dr. Demunick?
Yes.
Do you recall Attorney Brennan in his questioning asserting that you had no basis and there was no support for your methodology of pattern recognition? You recall that discussion?
Objection.
Sustained in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog wounds? Do you recall that?
Yes.
Can you please take a look at Exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
Yes. So this is an article that was published in the International Journal of Legal Medicine, and it is entitled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla, and that means upper, lower and upper. Maxillar is the upper. Maxilla, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed. The canine masseter pterygoid complex is short and strong, and its insertion on the mandible provides powerful mechanical advantage. So that's talking about the muscles, how powerful they are. And then it goes on to measure the forces.
If you could find the location, if there's any in there with regard to pattern, is there any discussion about attributes and patterns in that study?
Yes, this next paragraph. The above features attribute to the characteristics of dog bites. The maxillary teeth distal to the mandibular teeth allow the so-called scissor bite in which the dog can lock onto his prey. The tremendous force of the bite, muscle complex can develop, allows the dog to twist and tear, and cause great damage. The injuries caused involve a combination of biting, crushing, tearing that results in characteristic patterns of punctures, lacerations, avulsions of the skin and soft tissue. Forensic pathologists noted the multiple torn wounds with adjacent puncture wounds, the so-called hole and tear combination. That's in this case. The puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretching lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to one another, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis, with bites of other animals, which are not accompanied by pulling and shaking, nor by the usage of prominent canine, and with stab wounds caused by sharp instruments.
Does that study support or not support in the literature a pattern recognition methodology?
That's sustained.
What do you conclude from the language you just read in that study with regard to methodology of discerning dog bite wounds?
That pattern recognition is very important.
Now what I would like, if I could approach Your Honor.
Okay.
Sure. 298. If I could return this to Madam Court Reporter and please request Exhibit QQQ for identification. Thank you, Madam Court Reporter. May I hand it to the witness?
Yes.
Thank you, Your Honor. I've now handed you what is marked for identification as Exhibit QQQ. I would ask, please, that you, is that the Pollock study that you referenced in your direct and in your cross-examination?
Yes.
Could you please, as you did with the Munich study, can you please articulate the relevant, just the relevant sections with regard to your reliance upon that study?
Yes. So this is an article from the Institute of Forensic Medicine at the University of Vienna.
Is that a peer-reviewed study?
Yes.
Please continue.
Excuse me?
Please continue.
Okay. The title of the article is Fatal Dog Bite Injuries. And there's a summary. It says the dog's front teeth. So let me preface this. This was talking about a deceased child. And they describe the features. It says the dog's front teeth left marks of individual circular or scratch-like abrasions, as well as slit-like skin severances. Slit-like skin severances of the skin, arranged in curved lines. The pattern of the skin lesions largely corresponded to the anatomy of the dog's set of teeth. No tissue defects could be detected.
And is there any other section of that study that references pattern and pattern recognition methodology? Any other
Yes.
words, any other section? And if so, could you please read them?
Yes. So on page 491, there's a section called the Morphology of Dog Bite Injuries.
What does morphology mean?
It means the shape. And so it goes on to say the anatomy of a dog's teeth is the key to interpreting injury findings. The particularly long, cone-shaped, pointed canine teeth often create sharp-edged wound slits that can be mistaken for stab wounds. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors leave an impression, smaller skin lesions, parentheses, round pressure marks or streaky glide marks, can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors will act uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat that?
In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly.
Is that sentence relevant at all to what you've referenced as an incomplete bite?
Yes.
How is it relevant?
Because if not all the teeth impact, then you get a partial bite. You get irregular appearances. There's another sentence that's important here. A gap in the injury pattern can have several causes. Oblique biting, so what that means is not dead center on, but off to the side a little bit. Oblique biting. Curvature of the body surface, which we could have in this case around the arm, the edges of the arm.
Mr. Wu, could you please put Exhibit 1 back on the case? And Dr. Russell, would be helpful as you're discussing these items if you could determine whether or not what's discussed in that study is at all depicted in this exhibit.
Okay. So we discussed oblique biting, which is off at an angle. Curvature of the body surface. So here we have a body surface that's actually quite irregular. There's curvature down here. There's definitely curvature around the elbow, and so there's curvature around the bones. So curvature of the body surface can change the appearance of the wounds. Interposition of textiles, so that would be clothing.
Is there an example of interposition of textiles in this case?
I don't think so.
Well, was the decedent in this case wearing any? Is textiles mean clothing?
Yes, and I thought you meant in this article. But yes, there was textiles in this case. Mr. O'Keefe was wearing that hoodie sweatshirt or sweater shirt. So interposition of textiles, and then it goes on to mention some other things which I don't think apply in this case, such as different tooth lengths, tooth loss, abnormal teeth.
And is there any other aspects of that study that are relevant to your analysis and methodology with regard to evaluating the wounds in Exhibit 1?
You know, a lot of this article is relevant, and I don't know if you want to keep.
I want to
reading.
keep reading it, but if there is a section, because then I'm going to have a few more questions once you're done identifying the most relevant sections of the article.
Yeah, this. And then there's one section that says.
Thank you.
Oh, yes, thank you. Then it does mention that in some victims, parallel scratch marks originating from clawed paws are found accompanying the injuries.
And is there any other section that you believe supports your evaluation of the wounds on Exhibit 1?
No, I think that's it.
All right, so thank you, Your Honor. May I approach?
Yes.
Thank you, Dr. Russell. Thank you, Madam Court Reporter. So do those studies, the Demunic and the Pollock that you just referenced, do they support the methodology of pattern recognition that you applied in evaluating Exhibit 1?
Absolutely.
And do they directly or indirectly support that methodology?
Directly.
And is that medical literature peer-reviewed support or not for your pattern recognition methodology?
Yes. So as to the form, Mr. Leslie.
Do those studies, each of them, those peer-reviewed studies, support your pattern recognition methodology that you applied with regard to Exhibit 1?
Yes.
Did those studies look solely at individual wounds, or did those studies' methodology look at the overall pattern to evaluate and discuss wounds from dogs?
Ask it differently.
How did those studies evaluate wounds with respect to individual wounds and overall wounds? How did the study evaluate those?
They described some individual wounds. There were numerous wounds. Described some individuals, but they looked at the overall pattern to make recommendations.
Was the pattern, overall pattern in those studies important or unimportant in the analyses and conclusions that those authors reached?
Important.
Now let's switch topics. Attorney Brennan asked you about various considerations you made with regard to differential diagnosis. Do you recall those?
Yes.
Let's just start with your differential diagnosis methodology. You describe whether or not you took into consideration additional information that was presented to you in determining whether your initial hypothesis was correct or not. Describe just generally that process and whether or not you took new information and retested your hypotheses. Describe that process that you undertook just generally.
So in general, when a physician is presented with a set of circumstances or wounds or symptoms or whatever, they come up with a possible diagnosis, but have to consider other diagnoses as well. That's what a good physician does. They consider what they think is the most likely, and then they go through a process of eliminating the or including and the other possibilities. Would you like to give an example, like chest pain or
well, I'd like
pain?
to give you an example of what you used here in this case as the application of that.
Well, okay, so I'm just describing the overall process, because if you came to a diagnosis and narrowed in on it and never considered any other information, sometimes your diagnosis is going to be wrong, and so you have to allow for other information. And so I did that in this case. I examined the circumstances, examined the wounds photographically, and came up with my impression. But I also considered other possibilities. What else could cause those scratches or those abrasions?
And did you honestly and scientifically consider those other possibilities as you continue to review the information, old and new information in this matter?
Yes.
And did that process allow you to avoid confirmation bias?
Yeah. Yes.
So in terms of that process, now let's go through some of the items that Attorney Brennan discussed with you. He asked you several questions, one of which, did you evaluate news clips and audio clips? You remember that questioning?
I remember a question about some news clips.
And did you recall your discussion with Attorney Brennan about acute grief reaction? You remember that discussion?
Yes.
Now, in terms of acute grief reaction, you talked about it, and do you recall discussing that sometimes people who have a traumatic event, that acute grief reaction occurs? You recall that discussion with Attorney Brennan?
Yes.
Now, do you recall also mentioning that sometimes these patients engage in self-blame?
Yes.
And my question, among others, is when they go to self-blame, from your experience as emergency room physician, seeing patients with this, as you discussed with Mr. Brennan, are there instances when patients blame themselves for something when they're not to blame?
Sustained.
Can you discuss what you meant by self-blame in acute grief reaction?
Sustained.
Your Honor, may we approach?
Okay.
May I have a moment, Your Honor?
Yes.
Thank you. Dr. Russell, do you recall questioning by Attorney Brennan with regard to some alleged clip with regard to a motor vehicle, the Lexus and the pedestrian in this case? Do you recall that discussion?
Yes.
And have you reviewed and Attorney Brennan asked you about the slide presentation, what Dr. Welcher did with regard to this supposed accident reconstruction? You remember those questions?
Yes.
Mr. Wilk, if you could please publish the slide from Dr. Welcher's presentation with the arm out in the glass in the back. Not that one, the one in this case of the Lexus and Dr. Welcher dressed up as Mr. O'Keefe and with the clothing in the back, but with his that would be toward the back of that slide presentation, probably around 130-ish, 120. That's it, yes. And what slide number is that? 109. So, Dr. Russell, can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in reverse with a direct impact on the arm. From your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer, right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and with your Honor's permission, show where the radius and where the ulnar bones are of the arm? The lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
The hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture, digital fractures. It depends on the circumstances.
Thank you. And do you, you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here, what is the likelihood of there being any fracture to any bone?
Objection.
Sustained in that form.
Do you have an opinion based upon a reasonable degree of medical certainty as to whether there would be any fracture to any bone?
I believe That there was a very high likelihood that there would either be a significant bruise or a laceration or a fracture of the bones.
Now let's go to, as I understand it, you have reviewed the autopsy report of Mr. O'Keefe?
Yes.
And you've reviewed the file, the medical records files, correct?
Yes.
Is there any indication at all of significant bruising to the right arm of Mr. O'Keefe?
No.
With regard to the lower extremities, from what is depicted here, meaning this impact, did you evaluate the autopsy and the medical records to see what evaluation was done of the lower extremities?
Yes, a very extensive evaluation of lower extremities was done.
What very extensive evaluation was done, and by whom?
By Dr. Scortibello, and it was both an external and an internal examination of the lower extremities.
Let's start with the internal examination by Dr. Scortibello. Could you please describe what type of internal examination she performed?
Well, she opened up the legs.
Sustained.
May we approach her? Or lunch?
All right, jurors, I'm going to send you out for lunch, okay? We'll see you at 2 o'clock. Yes, come on up. right, Chrissy, does that help?
Good. All right.
You're welcome.
Put us back in session. You may be seated.
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Dr. Russell, we left off talking on the topic of differential diagnosis, and more specifically, we were talking about the lower extremity, the leg, and you were mentioning we reoriented to Attorney Brennan's questioning in the area. Could you please describe for the jury your basis of differential diagnosis with regard to the lower extremities and the leg, and specifically with regard to the autopsy's analysis of that area?
Well, the autopsy doctor did a very thorough evaluation of lower extremities, and to include, the external examination, which is very important, as well as an internal examination of the extremities, the tissues beneath the skin in both legs.
And just briefly, how did she perform that internal examination beneath the skin to look at what was beneath the skin?
Well, to directly visualize those tissues, she had to open up the skin. So she opened up the skin in the legs from the buttocks right down to the bottom of the legs near the ankle, and then reflected or folded back the skin to examine if there were any injuries to the tissues underneath.
Were there any injuries to the tissues underneath from that examination?
There were no injuries that she mentioned, nor no injuries that I saw on the pictures.
And no injuries, did that include analyzing whether there was any inflammation?
No, you can't tell about inflammation, but I specifically looked at the area adjacent to a very punctate little abrasion on the knee, and I looked underneath of that area very carefully on the photograph, and there was nothing, no injury underneath, no bruising, no hemorrhage underneath that abrasion.
With regard to that, how did you describe that punctate? I want to make sure I got it accurate. By the right knee?
Abrasion.
Abrasion. Could you determine from that even the age of that abrasion?
I could not.
No further questions at this time, Your Honor.
Oh, okay. Brennan?
Could I inquire about scope?
See what's that by.
May I?
Yes.
Dr. Russell, I asked you questions about your past testimony regarding methodology. And when I asked you those questions and showed you some of your transcripts, would you agree with me that you have testified that there is no recognized methodology on diagnosing dog bite wounds?
No, I believe I said that there was no standard methodology or no standard guidelines as to how to diagnose dog bite wounds.
There is no accepted practice directing you on what is appropriate and what is not appropriate to identify a wound as a dog bite, is there?
There are no accepted standards.
When Attorney Lisi had you look at a couple of case files from the Journal of Legal Medicine, let me ask you about that. You're not suggesting that those articles substitute for the absence of standards in identifying dog bites from photographs, are you?
Before standards are created, there are usually articles that have recommendations upon which the standards are subsequently based.
That wasn't my question, so we're going to listen to the question, please.
Okay.
Those articles, whatever their value you think they are, they do not create a standard to apply for diagnosing or looking at a photograph and coming to a conclusion whether the abrasions are dog bites, do they?
Correct.
And so when he had you read pieces of these articles, had Attorney Alisi gone over these articles with you before?
Yes, we discussed them several months ago.
Did he point out parts of them he would like you to read?
I pointed out parts that I thought were significant.
In this article that was marked for identification, parts of it are highlighted. Who highlighted those parts?
Mr. Alessi highlighted those based on my recommendations.
So Attorney Alisi highlighted the parts he wanted you to read to the jury?
Yes, and I believe they were the same parts that I read last time.
Could we have Exhibit 1, please? Now, regarding the Munich article, that was a case study on the unfortunate death of a young girl, yes?
Yes.
Who was attacked by or bitten by up to 3 different dogs.
Yes.
And it was a neck wound from which she bled.
Yes.
Very, very unlike what you're looking at here.
Yes, but that's very typical of an article, scientific article. They will present a case study and then present the research behind what they have seen in other articles and make recommendations.
I'm not asking you to defend that it's different. I'm asking you if it is different.
Oh, it is different.
Very different, isn't it?
Yes, that neck wound, yes.
Extraordinarily different.
Yes.
And so when you read this, let me ask you a couple questions. In this article, it talks about the characteristics of dog bites, doesn't it?
Yes.
And it talks about the maxillary teeth distal to the mandibular teeth allow the so-called scissor bite.
Yes.
So when the dog clamps down, the teeth kind of go to the side to tear the skin.
I didn't interpret it that way, no.
Okay. A scissor bite is when a dog bites down, yes?
Yes, I believe that what they were describing was the dog bites down.
And when it bites down, it anchors. That means teeth on the bottom, penetrate, puncture, yes?
They can, but they don't always puncture.
And then the top is a puncture. If you're going to scissor, it requires a puncture, doesn't it?
It's a mechanism. It's a movement. What they're describing is a move. And the way I read it, the way they described it is a movement like a scissor, where it's open and it's closed. It doesn't mean anything about how deep they penetrate.
There are no scissor bites on that wound, are there?
I don't know. I see 1 or 2 things that show up what I think might be upper and lower, so it could be.
Would you define any of those abrasions as scissor bites, Dr. Russell?
We talked earlier about how these marks here may be lower. I'm not going to define it. No, I can't say for sure that there's a scissor bite, but I see things that appear to be characteristics of upper and lower teeth.
I'm asking you about scissor bites. Please listen to my question. There is nothing on that wound that is consistent with scissor bites, is there?
I don't know.
Well, you're the expert. So when you look at that, can you point whether there's any wounds that are consistent with scissor bites?
According to their definition, and that's not an accepted definition, but according to what they were describing, and I believe what they meant was an open and closing of the jaw as the scissor activity, I believe that there's possibly 2 areas where I see that.
You're now saying this article that you relied on redirect examination is not an accepted authority?
I'm not saying it's not an accepted authority. It is a peer review article.
The injuries caused involve a combination of biting, crushing, and tearing. Do you see any crushing or tearing in those abrasions?
There's no crushing or tearing here, but does not mean that there has to be crushing or tearing.
I'm reading your article. I'm just reading verbatim, and I'm asking you about it.
Yes, and I'm trying to explain so that nobody gets nobody misunderstands this.
Crushing and tearing that result in characteristic pattern of punctures. A puncture is when a tooth penetrates the skin and there's some depth to it, correct?
Yes.
Show me one puncture, anyone, on that wound.
Okay. There are no punctures on this arm that I see. However, again, the wounds don't have to have every single characteristic. It is it depends on the force of the bite, how the wounds are going to appear.
The injuries caused involve a combination of biting, crushing, and tearing that results in a characteristic pattern of punctures, lacerations, and avulsions. There is no punctures whatsoever in that wound. Would you agree with me?
I agree.
There are no lacerations in that wound. Would you agree with me?
I agree.
There are no avulsions in that wound. Would you agree with me?
I agree. However,
I'm just asking you the question, Dr. Russell.
So you can maybe ask her.
Specifically, this study says the injuries cause a combination biting, crushing, and tearing that result in characteristic pattern of punctures, lacerations, and avulsions. They name 3 things that are characteristic traits of a dog bite, and you would agree not one of those 3 traits is present on the arm of Mr. O'Keefe. Would you agree with me?
I agree. However, in that case, those were dog bites that killed the victim. In this case, we do not believe that these dog bites killed the victim.
When they were discussing this article on the victim who was killed, do you realize when they were giving background, this background has nothing to do with the case study? This is general background I just read. Do you realize that?
They were investigating fatal dog bites.
Do you realize that is not qualified in this article? You realize that?
I realize that they were commenting on fatal dog bites. This is not a case of a fatal dog bite.
This article, I'm going to show it to you. May I approach?
Yes.
In the highlighted paragraphs that Attorney Alisi had you read, that is describing the background of dog bites, not this fatal attack. Would you agree with me?
The title of the... No, I don't agree.
Okay. I move to introduce this as an exhibit, please.
Mr. Leslie?
I have no objection, Your Honor.
Is it 210?
In the other article that you read from, that was highlighted as well. Who highlighted the portions you were to read?
Mr. Alessi.
It describes that teeth from a canine create a stab wound-like skin laceration. They can do that, right?
They can do
Do you
that.
see any stab-like wound lacerations to Mr. O'Keefe's arm?
No.
It talks about punctures. And again, we've discussed this. There is 0 punctures on Mr. O'Keefe's arm, correct?
Correct.
You said that when somebody is in a collision, that they can suffer injuries such as bruising or breaks.
Yes.
We've also discussed when a person is impacted by a vehicle, it can result in a variety of different injuries or no injury at all.
Correct.
There's a number of dynamic factors involved that are very difficult to assess and predict, correct?
Correct.
And in this case, you did not do any accident reconstruction to try to identify the details of the mechanism of injury to John O'Keefe, did you?
I did not do accident reconstruction.
And so, having not done accident reconstruction, would you agree it's fair to say that you are not in an informed position to give an opinion as to how the injuries could or would have happened in this case?
I disagree.
Specifically, you were asked questions about the impact or collision in this case. How fast was the defendant's Lexus traveling when there may have been an impact in this case?
I understand possibly 24 miles an hour.
Who picked that number?
I have no idea.
Well, you heard it from somewhere and you've just given an opinion on it. Where is that number committed to or derived from?
I don't know.
Well, if you're going to give an opinion based on what you're portraying as facts to this jury, you should have some certainty about the source of your material, shouldn't you?
You know, I'm an ER doctor, so in the ER, I've treated thousands of motor vehicle accident cases. And most of the time, I do not know what speed the vehicles were going at. I've never done accident reconstruction. I don't know any ER doctor that does accident construction or is trained in accident construction. It's not part of the job.
I totally agree, but you're having opinions you're giving on behalf of Mr. Alisi, and that's why I'm pressing you on these issues. Do you know, you don't know the movement of John O'Keefe before any potential strike or collision, do you?
I don't know the movement of most of the patients I've seen in my life before or immediately after the impact.
Of course, you wouldn't know the body angle because you weren't there.
Right.
So when you're asked to give an opinion whether this was a clip or a direct strike, you're really not in a position, having not been an accident reconstructionist and not having been there, to give that type of information, are you?
I wasn't asked to give an opinion about whether this was a clip or a direct strike. I was asked to give an opinion about these wounds caused by a motor vehicle collision.
So you would agree with me, you are not in a position, based on your opportunity to view evidence and your experience, to give an opinion about what injuries would have occurred in this event?
No, I disagree.
And so you think you can give an opinion about the extent of injuries, even though you are agreeing, not only you're not an accident reconstruction expert, you have no idea about the details of the collision in this case, Dr. Russell.
Mr.
Is
Brennan,
that true?
I have no details about the collision?
About what happened during the collision. You have no details about the body movement, the placement, the speed. You don't have any details that you know of other than what was told to you, correct?
Objection, Your Honor. Sustained.
There are dozens, hundreds, thousands of motor vehicle accidents in which there are no lower body brakes. Fair to say?
Probably, yes.
You mentioned bruising. What do you do to treat for a bruise? If someone's has some type of pressing and the bruise before it really forms, what's the best way to treat it?
Well, it depends on the bruise. It depends on the location. It depends on whether or not there's continued bleeding in the soft tissues. It depends on whether there's compression of the blood vessels. and and or the nerves underneath. And then, and of course, you want to examine adjacent structures for fractures and other injuries. And then after all that, if you've ruled out major, other injuries, you treat the patient for pain.
You ever prescribe ice?
Oh, yes.
So if a person was lying prone in the cold winter on the front yard on the dirt and was being covered by snow, sub 32 degrees, and the body temperature were to drop from 96.8 to about 80 degrees, would that have a similar effect to ice on the area that may bruise?
Not exactly. You want me to explain?
I do.
Okay, yes. So as the snowflakes fall, yes, there will be a gradual lowering of the body temperature and gradual effect on the body. Now, as opposed to in the ER or in a medical setting, if I or another practitioner, and by the way, nurses and nurse practitioners and PAs also treat dog bite wounds. But if another practitioner, a practitioner gives the person an ice pack, they get immediate coldness and immediate significant change in temperature to that area.
Assume the weather is so cold that the cell phone battery on someone's iPhone begins to plummet regularly in degrees.
I have no idea.
Objection, Your Honor. So the objection system.
Thank you. When you came to your conclusion, considering what you see in this picture, and Attorney Alisi was asking you about fragments from a broken taillight, did you know or consider that Mr. O'Keefe, sometime around when he incurred these wounds, had a piece of glass stuck in his nose?
Objection, Your Honor. Sustained.
Finally, Dr. Russell, you said during your differential diagnosis you consider information, you either weigh it, accept it, or you distinguish it and you disregard it, correct?
Yes, generally.
During your differential diagnosis, you've referred to a number of different people studies, things that you haven't done yourself, but you've looked at other people's efforts. One of the things you looked at was the deputy medical examiner from the Forensic Pathology Investigations Division of the Armed Forces, a person by the name of John C. Walsh, correct?
Objection, Your Honor. I'm going to allow that.
Would you like me to ask that again, Dr. Russell?
No, you don't have to ask it. I read that report, yes.
And John C. Walsh is a doctor, correct?
Yes, that's what it says.
And do you have any understanding that he works with the Forensic Pathology Investigations Division of the Armed Forces?
Yes, and therefore his practice may be limited in scope.
Well, you are trying to qualify what he doesn't do. Do you know if his practice is limited in scope?
Typically, the medical examiners that work for the armed forces often have a specific practice that is limited in scope.
Do you know anything about Mr. Walsh and his practice?
No.
Why do you find the need to try to undermine the extent of his authority before you know anything? Why is that important?
Objection.
Sustained.
You don't know what his scope and practice is, do you?
No, but I always look at where the person works that writes a report in terms of physicians and what their possible experiences are. Do they work in a medical examiner's office in Alaska or Hawaii or a big city or a little town? I look at those things.
When you considered his opinions after his review of these materials, did you consider when he offered in his report that multiple abrasions ranging in size from 2 to 3 millimeters up to 7 centimeters were documented on the decedent's right arm?
Yes.
These injuries do not photographically appear to be, nor are described as puncture bite wounds, and thus are highly unlikely to be the result of an animal bite attack. The abrasions are non-specific Abrasions occur as the body moves over a blunt or rough surface such as a skinned knee. Did you read his report and consider it?
I did. However, I don't know if he's ever had any experience with dog bites examinations. So I had to consider that and weigh it.
I have no further questions. Thank you.
Dr. Russell, there were questions with regard to highlighting of articles. Did I determine which parts were to be highlighted, or did I merely perform the function of highlighting the parts you wanted me to highlight because you didn't have a highlighting function with you traveling from California?
That is correct. It's the second one.
With regard to these articles, you mentioned a methodology in connection with them and a pattern recognition methodology. Was it the purpose of citing this article to say that they're just like this situation, or was the purpose to say that there is a methodology in the literature to determine how to determine whether a wound is from a dog?
Objection.
Sustained as to the form.
Dr. Russell, what is the purpose? Let's just start with the DeMunick article that was talked about, because these articles were discussed. What was the purpose of you citing to those articles?
The purpose was to identify that pattern recognition is an important component in identifying wounds, and particularly in dog bite wounds. It did not mean that the victim had to have every single characteristic that was listed. And it just was focusing on things to look for and the patterns. It was not just that there's one individual wound that's going to be diagnostic, but that there are patterns for the physician to look for.
In terms of Attorney Brennan asked you, and so now with regard to the Pollock article, in terms of the Pollock article, is there any discussion in this article about whether the spectrum of injuries to which you can apply the mechanism and the methodology, is there anything in there about whether the pattern of injuries can be diverse or whether they're all the same? Does Pollock speak to that?
He does.
And what does Pollock say about whether or not the spectrum of possible injury forms when you apply this methodology can be diverse? What does he say?
Well, he mentions about the actual surface of the body that is impacted, if there's any curvature to that surface, if there's any structures underneath that would affect the bite. Those are, and if there was material or textiles or fabric that were in between the bite and the skin, and there were other factors too.
Okay, thank you. Now, lastly, what I'd like to cover is Attorney Brennan discussed the Dr. Walsh. May I approach, Your Honor?
Okay. Did you show Mr. Brennan?
He's the one who gave me it.
Okay. I didn't know what you had.
Yes, thank you. So may I hand to the witness?
Yes.
May I stand here, Your Honor?
Yes.
Thank you.
Just step back a little
Yes.
bit.
Yep. Step back a second. Dr. Russell, what I would like to do is to give the jury a fair
Objection.
I'll withdraw it.
Objection. Commentary. I'd like to be heard.
Why don't you bring the reports over? Okay.
May I return next to the witness stand, Your Honor?
Yes.
Thank you. May I proceed, Your Honor?
Yes.
Thank you. Dr. Russell, I am re-handing you this letter from Dr. Walsh, and what I am going to do, and you just tell me if I do it correctly, I'm just going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances or events surrounding the death. The absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor. Thank you, Dr. Russell.
All right, Dr. Russell, you are all set.
Thank you.
I'm going to have this marked for identification.
Thank you.
RRR for ID.
Thank you. And the next witness is who?
Sorry, Your Honor.
Who's the next witness?
If I may, Your Honor.
Yes, just tell me the name because I need to know whether we need to go to sidebar first. Okay, thank you.
So you're going to step up, face the clerk, and raise your right hand.
You solemnly swear the evidence you give to the court and jury in the case down here and the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Maybe seated.
Good afternoon. All right, Mr. Jackson, you are all set.
Thank you, Your Honor. Good afternoon, sir. How are you?
Good afternoon, sir.
Could you please state your full name, spell your last name for the jurors, please?
Nicholas Barrows, Barros.
And where do you currently work?
The town of Dighton, Dighton Police Department,
How long have you worked for the Dighton Police Department, sir?
since 2011.
And what's your position there currently?
Currently, I am a sergeant.
What's your duty assignment as a sergeant? What do you do?
I supervise the 4 to midnight shift.
We'll get to that in a little bit more detail in just a second. A couple more foundational questions. How long have you been a police officer altogether?
Since 2011, so going 14 years.
And what education and training and background do you have that qualifies you to do your duties as a sergeant, a supervisor at the Dighton Police Department?
I completed the police academy. I hold a bachelor's degree in criminal justice. I've been to many trainings as a police officer and as a supervisor.
When did you get your bachelor's degree?
2012.
Is the Dighton Police Department an autonomous police department for the city? In other words, is it a branch of, say, for instance, Massachusetts State Police, or is it an autonomous department?
It's on its own.
Okay. It's not in any way connected to the Canton Police Department, I presume?
Correct.
Is it in any way connected to the Massachusetts State Police
It
Department?
is not.
As a supervisor, are part of your duties to oversee subordinate officers in their daily fare, whatever that may be?
Yes.
Does that include anything having to do with crime scene investigation?
To an extent.
Witness interviews?
No, that would be the detective bureau.
What about working and coordinating with detectives?
To an extent.
Collection of evidence or working with detectives as they collect evidence?
They would collect evidence.
Maintaining crime scene protocols, things of that nature?
Correct.
All right. As a sergeant with the Dighton Police Department, are you a trained observer?
I am.
Would you consider all of your subordinates, the patrol officers, day-to-day officers, Are they also trained observers?
They are.
Is that part of policing?
It is.
Describe that a little bit for the jurors so we understand.
We are in the police academy. We're told to watch everything. It's our heads on a swivel. We are always looking because we don't know what the unknown is.
When you say you don't know, is it true that you don't necessarily know what might become relevant later that may be needed in court?
Correct.
I want to draw your attention to January of 2022, a few years ago. January 29th, 2022, did you have you personally, officer, did you have any personal relationship with the Canton Police Department?
I did not.
Did you have any personal relationship with a trooper from the Massachusetts State Police named Michael Proctor?
I did not.
Do you have any relationship with a person by the name of Brian Higgins, an ATF agent?
I did not.
Do you have any relationship with a Boston police officer known as Brian Albert?
I did not.
Did you know any of the witnesses or individuals involved in an ongoing investigation related to the death of Boston police officer John O'Keefe?
I did not.
On January 29th, 2022, did you receive some sort of a call to respond to a particular location? I don't want the address of the location. We'll get to that in a second. Did you receive some sort of a call in the afternoon?
I did.
Describe that for the jurors, please.
Around 2:30 in the afternoon, I received a call from the troopers assigned to the Norfolk District County DA's office in regards to a vehicle that was at a residence in the town of Dayton.
What were you asked to do? Why did you get that call?
The troopers said that they were coming into my jurisdiction, and as a courtesy, they wanted me to respond with them.
Is that sort of normal protocol? If you go into somebody else's jurisdiction, you let them know?
Yes.
So that was not necessarily unusual?
No.
About what time did you receive that first call?
The first call was around 2:30 in the afternoon.
Was there are logs kept of those kinds of things? If you get a call, you respond to location?
Yes.
At some point after you received that first call, did you receive any other call specifying a time of arrival for the MSP troopers, anything like that?
I did.
Describe that for us.
I got a second call around 3 p.m. From Trooper Michael Proctor stating that he was about 10 minutes away from the address in Dayton.
At the point that you spoke with Michael Proctor, had you ever spoken to him in your professional or personal capacity ever before?
Never.
Did you know the name? Did you know who he was?
I did not.
Complete stranger?
Complete stranger.
What time did you actually arrive at the residence?
I arrived at the residence, I believe it was 3:27 p.m.
Sergeant Barrows, did you, I don't want the address, cameras are rolling, did you respond specifically to a residence in the city of Dayton?
Yes.
Did you at that time know who lived at that residence, who resided there?
I did.
How did you know that?
Early in the shift, when I came on at 8 a.m., the midnight shift, the outgoing shift, had told me that a resident of Dayton at that address had called looking for a ride to Brockton Hospital.
Who did you know at that time, or who did you believe at that time to live at the address that you are now responding to?
William Reed.
That was Reed, R-E-A-D?
Correct.
Okay. Did you know anything about his daughter at that time, or did you just know the name William Reed?
I just knew William Reed, the name.
At the time that Michael Proctor called you, did he say anything about what his intentions were once he arrived at the location?
Yes, his intention was to retrieve a vehicle that he said was involved in a homicide.
Did he specifically say to you at 3 o'clock-ish in the afternoon he intended to seize the vehicle?
I believe the first phone call, that was his intention.
Meaning all the way back to 2:30?
2:30 is when he first called me and said that they were coming to Dayton to retrieve a vehicle that occurred in a homicide in Canton.
And you understood that to mean what? Retrieve a vehicle?
Seize.
Thank you. What was your role once you arrived at the scene at the Reed household?
My role was Trooper Michael Proctor asked me to facilitate a tow to tow that vehicle.
Was that a private tow company?
Yes.
And when you say facilitate a tow, what does that mean?
He asked who we used for towing vehicles, and during that period of time, it was Diamond Towing.
Did Diamond Towing ultimately show up, a representative of that
They did.
tow company, with a tow truck?
Correct.
A flatbed?
Yes.
Who was with Trooper Proctor when you arrived at the scene?
Sergeant Buchanan.
Had you ever met Sergeant Buchanan before?
Never.
Did you know him?
Nope.
Did you know him professionally or personally?
Never.
Had you ever spoken to him?
Never.
Ever? I'm so sorry. It's getting late in the day, and I guess I'm going too fast. Sorry, my fault. Let's start that just a little bit slower. Did you know him?
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
No relationship whatsoever?
None.
Same with Trooper Proctor?
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes, once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
What were you driving?
I was driving a Ford F-150 police cruiser.
A police cruiser that's a Ford F-150?
Correct.
They have those?
Yes.
Cool. Were you in full uniform?
Full uniform.
Gun, badge, the whole works?
The whole works.
Did you ever go inside the house?
Briefly.
What was the circumstance of going inside the house?
I went inside to let the troopers know that the tow truck operator was there, and I also went in to ask how we're going to get the tow truck into the driveway because there was about a foot of snow.
Okay. That sort of answers my next question. Did you see whether or not Trooper Proctor and Sergeant Buchanan actually did go inside the residence?
Yes, they did.
For the bulk of the time that they were in the residence, where were you?
Outside the residence.
Were you with the black SUV?
I was in the garage speaking to the defendant's mother.
The defendant's mom?
Yes.
Janet? Okay.
Yes.
Where was the SUV at this point?
In the driveway.
Did you have an opportunity to see the SUV?
I did.
Did you walk all the way around it?
Not all the way around.
Did you see the rear end of it?
I did.
Did you make note of the rear end of it?
Yes.
How long would you say you were at the location in a position to observe the rear end of that SUV? 2 minutes, 20 minutes, something in between? Longer?
I would say not the entire time that I was there, but a good amount of time.
More than a glance?
Yes.
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant Buchanan, correct?
Correct.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight.
Can you describe for the juror, by the way, which taillight are we talking about?
The right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that description is?
There was, it was damaged, the taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big.
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere in there.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked. Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear taillight.
Of what?
The Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight the day I was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear taillight, please?
Okay.
Do you see the condition of that taillight as it's depicted in this photo?
I do.
Sergeant Barrows, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
What's different about this photo, sir?
That taillight is completely smashed out.
Does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence?
Objection.
Sustained. Ask it differently, Mr. Jackson.
Of course. Describe specifically, other than the fact that it's different, describe in detail for the jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there. Towards that right side where that large chunk is, that's what was missing.
I'm going to hand you a green laser pointer. If you can, there's two displays, one monitor directly in front of you and one to your right. If you could use the one to your right, it's a little easier on the jurors. Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
May I approach?
Yes.
If the entire taillight had been broken out as it's depicted in this photograph, would you have made note of that?
Objection.
Sustained.
Do you believe you would remember if the taillight, well, let me ask it a different way. The piece that you saw missing, but not completely damaged, is the reason that you use the phrase not completely damaged to highlight the fact that there was still more taillight attached to the vehicle than is depicted in this photo.
Sustained.
We can take this down. As you sit here and recall back to that, your observations, and you observed this for over the course of how long would you say? How many minutes?
Probably 20 minutes or so.
You actually wrote a report about this, correct?
Correct.
And you documented your observations, correct?
Correct.
In your documented observations, did you use the phrase cracked but not completely damaged?
I did not.
Sustained.
You've testified previously,
I have?
about a year ago.
Yes.
Did you use the phrase cracked but not completely damaged then?
The objection sustained, Mr. Jackson.
Ultimately, was the black Lexus SUV towed and cleared from the scene?
It was.
Is it your responsibility or part of your responsibility to log the time that things like this happen, like, for instance, the SUV is taken away?
When I cleared from the scene, yes.
What time was that when you cleared the scene?
I believe it was 4:17 p.m.
Suffice it to say that SUV was not seized at a later time, correct?
Correct.
It was not seized at 5:30 p.m.?
No.
I'd like to show you another exhibit, if I could. This is Exhibit 105. Do you recognize this scene generally?
I do.
Do you recognize it as being, what do you recognize as being?
This is the Reed residence.
Do you see some vehicles in that still shot of the video?
I do.
Describe what you see.
That tow truck is diamond towing, and that other vehicle that's at the rear of that tow truck is the Lexus SUV.
if we could, with the court's permission, zoom in. It's high on the screen, correct?
What's that?
The vehicles are high on the screen as we're
Correct.
looking at it. Could we zoom in to the top left portion of the screen?
Okay.
Can we play this video?
Yes.
Thank you, Your Honor. Can you see what's depicted in the still image of that video right now?
I can.
I'm going to ask you if you'll turn to your right, concentrate on this area. This area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
Does it look clear? Does it look like it's shining red?
Looks clear.
The portion that is intact, does that appear to be brighter red?
Correct.
And the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase that?
Sure. Let's go back. You see the red?
Yes.
All right. Is that the condition of the taillight as you saw it on January 29th around 3:15 or 3:30 when you got to the location?
It was.
Let's go back to the other exhibit, please. Exhibit 13. Can we zoom in, please? Can you see that this entire area is now missing?
I can.
Sustained. Just ask it differently.
Sure. The area that I'm circling here, do you see any red lens in that area?
No.
Is that consistent, this photograph consistent with the condition of the taillight as you saw it on January 29th, 2022, at just after 3 o'clock in the afternoon?
Absolutely not.
Thank you.
Lights, please. Thank you.
Thank you. Good afternoon, sir.
Good afternoon.
Have we met before?
We have not.
Do you still work in Dighton?
I do.
At the time you went to the Reed residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed
Nope.
or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene?
Yes.
Because it's your jurisdiction?
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it?
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
I wouldn't say that they told me what the process was going to be.
When you got there, were the troopers already there or did they arrive after you?
The troopers were there.
Were they in the house or outside of the house when you got there?
They were outside in a pickup truck.
Did you see them get out of the pickup truck after you got there?
They got out after I identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
Did you see them do anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went inside the house?
What do you mean by spoke to me?
After they introduced you introduced yourself to them, they went into the Reed house?
Yes.
And then they came out?
They came out much later.
And that vehicle was towed?
Correct.
At no time from when you got there until you left did you see anybody from the state police in any way tamper with that vehicle, did you?
I did not.
When the vehicle was towed, do you know how long it took to take the vehicle from Dighton back to Canton?
How long?
Yes.
I do not.
You didn't escort it back.
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
I could have.
You could have gone into detail about the width of the damage.
I could have.
You could have taken photographs of the damage if you wanted to.
I could have.
In fact, there was no limitation on what you could have written in your report regarding the damage, was there?
No.
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Because in time, your memory is not always as good later on than it is at the moment.
Correct.
What might be important or remarkable later might not be remarkable at the time you're making the observation.
Correct.
So you're taught at the academy to use as much detail as you can so that you can have an accurate memory later on.
Correct.
Because oftentimes, well, you respond to a number of different events and incidents, don't you?
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but...
Did you at the time?
At the time, correct.
Yeah. And so it's sometimes difficult to remember the details of all events, and you use the report to refresh your memory.
Correct.
When you wrote your report, and you could have put as much detail as you wanted, is it fair to say you only wrote one single line about the damage to the car?
Correct.
The vehicle had damage to the right rear taillight.
That's what I wrote.
Fair to say you didn't document that it was the size of a dollar bill. You didn't say that, did you?
No.
Or that it was 3 to 6 inches. You didn't mention that, did you?
No.
You didn't mention the placement of where the damage was.
To an extent, I did the right rear tail light.
Right rear taillight. You didn't indicate if it was on the side or on the back.
I did not.
You didn't provide any other details of your description when your memory was probably at its best. True?
True.
And would you agree that your memory that day was probably much more accurate than it is today?
I would not.
When you wrote the report, did you ever have an opportunity to write a supplement report if you wanted to give more detail?
I guess I could.
You didn't.
I did.
Inevitably, you were a witness at trial. I'm sorry, you were a witness at a prior proceeding in this case, weren't you?
Correct.
You came in and you swore under oath regarding your memory.
Correct.
And that was probably a year to a year and a half after you first made the observations which you reduced in writing in the police report.
Correct.
And when you made those observations, that was on January 29, 2022?
Correct.
When you came into court and you testified, that was on June 10, 2024.
If that was the date.
You were asked questions to use your best memory to describe the damage to that taillight last time you swore under oath to tell the truth, weren't you?
I don't think I was asked that.
But were you asked to describe the best you could the damage to that right rear taillight last time you were in court on June 10, 2024?
I don't think I was told to describe it in depth.
Were you asked questions about the damage to that rear taillight last time you were in court?
I was.
And when you described the damage, did you do your best of your ability to give as much detail as possible?
I did.
Did you qualify your memory at that time, saying to the best of my ability and recollection?
I did.
And when you qualify as a police officer with the best ability and recollection, that is recognizing that time had passed.
Time has passed, yep.
That you had a report, that you could refresh your memory.
Correct.
And did you refresh your memory with that report before you testified last time?
I did.
And when you qualified that it was to the best of your ability and recollection, that account for the fact that when you looked at the report, there was no detail other than your commentary in your report that the vehicle had damage to the right rear taillight.
Correct.
And so when you qualified, you were considering human factors like time had passed.
Correct.
That your report was respectfully scant.
Correct.
That you had heard a lot about this case since that point, hadn't you?
Correct.
And so considering your memory in June of 2024, when you qualified your answer, was it considering all of those different factors that had passed in between that time?
Can you rephrase that?
Yes. When you decided to qualify your answer, and you said to the best ability and recollection, and then you went on to describe what you remember from the break of the taillight. Is the reason why you used that qualification to the best ability and recollection, is it because of those human factors that had passed?
I would suppose so.
And, sir, since the time you came into court on June 10, 2024, have you spoken to anybody from the defense about this case?
Yes.
How many times have you spoken to somebody from the defense about this case after you gave your testimony on June 10, 2024?
Once.
Where did you speak? Who did you speak to?
Attorney Jackson.
Did you speak to him in person or on the phone?
In person.
Okay, don't. Okay. You're not hesitating, are you?
No.
Where did you speak to him in person?
At his hotel.
How did you know where Attorney Jackson was staying?
He told me.
Did you find it odd to go visit an attorney at their hotel and talk about a case?
It was in their conference room.
Find it odd. Go to somebody's hotel to speak to them about a case.
No.
Without saying the name of the hotel, where was the hotel located?
Boston.
And where were you located?
I don't feel comfortable telling you.
I'm sorry. Did you have to drive?
I did.
So you took the effort to go to see Mr. Jackson at his request. Did you know who Mr. Jackson was?
I did.
Did you see him on TV?
I did.
When you went there to the hotel in the conference room, who else was there?
Attorney Little.
Okay. Who else?
I'm not sure of the other gentleman's name.
It was one of the gentlemen right here on the end? The good-looking one down there on the right?
No, it was not.
Somebody else?
Somebody else.
Okay. Was there anybody else there?
No.
When you were in that conference room, were you shown your police report?
No.
Were you shown your testimony from the last time you came into court?
No.
The photograph of the vehicle in the Sally Port, or the vehicle with the missing glass, were you shown that?
No.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that photo during your prior testimony, you never, ever suggested that that was in any way different than what you had seen in Dayton.
Nobody asked me that.
When you were asked to describe the damage, and you were shown that photograph, you never, ever suggested that there was a difference in the damage as you see it in that photo compared to what you remember, did you?
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last event that you testified at?
I testified that that was not the taillight the day that I saw it.
That's what you testified at the last event?
Did.
Yes?
Yes.
You said that photo does not depict what you saw?
Correct.
Yes?
Yes.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
Okay. And you remember making that comment under oath?
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dayton?
I do.
When you were asked questions about that taillight, you had described the taillight as not completely damaged, it was cracked, and there was a piece missing but not completely damaged. Remember that testimony?
I do.
And is that accurate testimony?
It's accurate.
So, in your memory, in June 10, 2024, was that vehicle's rear taillight had a piece missing, correct?
Correct.
You said that your memory about the damage to the taillight, as you recall it when you were in Dayton back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
Have you ever read your testimony from your last proceeding?
Never.
But you have a specific memory of discussing that specific photograph? Yes?
Yes.
May I approach?
Yes.
I'm going to show you your transcript of sworn testimony on June 10, 2024. And when you reflect on your memory, understanding some time has passed, you've testified that your memory of distinguishing that photo is reflected in your testimony, right?
Objection.
So ask the question differently.
Okay. Your memory is that you discussed the distinction between that photo and what you saw at the last time you testified.
Objection.
I'm going to allow that.
And as you take a look at it, could you show me anywhere in your testimony, anywhere, where you made any statement about that photo being inconsistent with what you saw in Dighton on January 29, 2022?
It's not in there.
Can I approach?
Yes.
I can put it back on. Thank you. So respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why at the academy they teach you when you write reports to be as detailed as you can. To accommodate the fact that memories can fade. Right?
Correct.
Memories can change.
I know what I saw, and that wasn't it.
Well, that's not what I'm asking you, because you just testified that under oath you had looked at that photo and distinguished it. But that's not accurate, is it?
No.
And so it's not a matter of you perjuring yourself or lying, it's a matter of difficulties with memory, wouldn't you say?
Yeah. Correct.
And you share those same difficulties with memory as many other witnesses. Objection.
Sustained.
You have, as is human nature, difficulties with memory at times, correct?
Correct.
And so that very certain memory you had about your testimony last year, fair to say that never happened.
Correct.
You were simply mistaken, weren't you? Or something more, please tell me.
Correct.
When you met with the attorneys in Boston, what did you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month. next months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what did you talk about?
Objection, Your Honor.
I'm going to allow it.
Over here. What did you talk about?
Excuse me.
So that, okay.
Over here.
You told us there was some background about being subpoenaed and time. Substantively, what did you talk about with the attorneys when you met them at their hotel conference room?
Other than that, they didn't go over my testimony. We just spoke about that I said that the taillight was not completely damaged.
Okay. Did you get into any detail about the conversation about your testimony today?
No.
When did you meet with them?
I don't have the date.
Last year, this year?
I don't have the date. I don't recall the date.
I'm not looking for a date, just the general year frame. Last year, this year?
Probably June. Early in this year.
Are you having some difficulty with memory about that as well?
On a certain date, yes.
Not a certain date. Was it this year probably, or do you think you met them this year?
This year.
Do you know what month you met them this year?
I wouldn't know the month.
Certainly you talked about this issue with the taillight, didn't you?
Yes.
When you talked about the issue with the taillight, did anybody from the defense offer you any opinions or information?
No.
Did they ask you questions about it?
No.
So you went to a meeting in a Boston hotel in a conference room, and nobody talked about the taillight?
Objection.
I'm going to allow it.
Sir, I'll ask you another question instead. Have you had an opportunity to see other evidence of that taillight being damaged that morning before you saw it?
On the 29th of January?
Yes.
No.
The video that was shown to you with the tow truck, had you seen that before today?
Yes.
Who showed it to you?
From seeing it on TV and...
Was it shown to you during your conference room meeting at the hotel?
It was not.
So you looked and studied and watched this case a little bit?
With all due respect, sir, I don't live under a rock. It's all over social media and the news. You can't avoid it.
I'm not criticizing you or discounting you. I'm just asking you. Have you been exposed to this case since you made those observations indicted on January 29, 2022?
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
and seeing this extraneous information, this other information, do you think that played a part in some of your difficult memory?
Objection.
I'm going to allow that.
Your Honor, can we approach?
Okay.
You've seen quite a bit of information about this case and the issue regarding the taillights since you first made the observations back in 2022. Wouldn't that be fair to say?
Would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
I guess.
No, I don't want you to guess. You testified that you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in direct examination under oath, and you tried your best about things that just didn't happen, right?
Right.
Would you agree that you have some difficulty with your memory?
I'd agree.
I want to show you some evidence of that taillight before you had a chance to see it in Dighton. If we could have the ring video at 5:07:58, please. Have you seen this video before, sir?
I have.
Okay. Before you proceed, Ms. Gilman, have you seen this on social media?
The news, social media.
Has anybody else shown you this video?
No.
How many times do you think you've been exposed to this video?
Too many to count.
Because you were involved in this case, and I'm going to say as a predicate, there were no orders for you not to look at anything. I'm not suggesting any impropriety. But because you were involved in this case and issues regarding the taillight, do you think you had a particular interest when things like this came on TV and social media to take a look to compare it to your memory?
Did I have a particular interest? No, I didn't follow this case.
But you've seen this many, many times.
Because of what is out there on social media and the news.
I understand. Can we play this, please? Turn the sound down a little, please. Thank you. Stop, please. Do you see that white part of the back rear right taillight?
Objection.
I'm going to allow it.
You see that? Sir?
Can you zoom in a little bit more? I can.
You can or cannot?
I can.
You can. C-A-N can?
Yes.
Thank you. Continue, please. Continue. Stop. Can you bring it back, Mr. Stone? Back more. Open, right there. Zoom, please. You see, sir?
I can see that.
Is that consistent with the damage that you saw when you looked at that Lexus in Dayton hours later?
Consistent.
Can we go to Exhibit 10, please? And before you show it, I have a couple questions. This was a snowstorm, kind of like a blizzard that day?
Yes.
And when you got to the driveway, it had not been shoveled or plowed.
Correct.
There was quite a bit of snow accumulating and ongoing.
Yes.
And there was snow coming down on top of everything, the ground, the streets, the cars, correct?
Correct.
And snow was accumulating, did you notice, on cars and packing onto cars?
Yes.
When you looked at this house, when you looked at the defendant's Lexus in Dayton, you didn't go over and scoop out any of the snow that was in that broken taillight, did you?
I did not.
You didn't try to remove any snow off it or that was accumulated inside of it?
I did not.
And the snow there was snow packed on that car, wasn't there?
There was.
There was snow packed around the light, wasn't it?
There was.
And would you agree with the snow, since you didn't tamper with it or try to remove anything, that could impede your ability to accurately observe the depth of the damage? Would you agree with that?
I would.
If we could have Exhibit 10, please. Does that appear to be the same Lexus you looked at when it was in Dayton? And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't.
Okay, we have Exhibit 11, please. Can you take a look to the right? You see that right tail light, the white part?
I can.
Missing, yes?
Looks like snow is packed on it.
Does it look like there's a red tail light there?
Does not.
This is before you saw the car in Dayton? Do you know that, or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observations in Dayton?
I do not.
The right rear taillight and the missing parts there, is that consistent with what you saw around 3:27 on January 29, 2022?
Yes.
I have no further questions.
Okay. Lights on, please. Mr. Jackson.
Thank you, Your Honor. I'll be brief. Sergeant, did you celebrate your birthday 2 years ago?
I did.
Kind of a big deal. It's your birthday, right?
Yes.
What day of the week was your birthday 2 years ago?
No idea.
Do you have a difficult memory, sir?
Yes.
The fact that you had a birthday, you recall, correct?
Correct.
The day of the week of that birthday may fall by the wayside in your mind, right?
Right.
Sustain us to the form, Mr. Jackson, is
Of
your
course.
witness.
The fact that you can't remember the day of the week, does that mean that you have a bad memory?
Objection.
I'm going to allow it.
Correct.
You remember being in Dayton, correct? Being called out to Dayton to the residence of the Reeds.
Correct.
Do you remember the time?
I do.
Do you remember the weather?
I do.
Do you remember who you met there?
I do.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
I do.
The second one?
I do.
Do you remember being in the garage and speaking with someone?
I do.
Do you remember it was this lady, pretty lady right here in the blue?
I do.
Do you remember meeting Mr. Reed?
Briefly.
Handsome gentleman with the gold tie?
I do.
You remember all that, right?
Mm-hmm.
Do you remember the SUV?
I do.
Do you remember the condition of the taillight?
I do.
You were asked whether or not you saw Trooper Proctor in any way manipulate that right rear taillight while it was out at Dayton, while you were there, correct?
Correct.
You said no. Honestly, I never saw him touch it, right?
Correct.
Were you in the Sally Port in Canton PD? I'm sorry, in Canton, in the Sally Port, at the police station?
I wasn't.
At 5:30 p.m.?
Sustain.
At any point, did you ever go to the Sally Port? at Canton PD that day?
I did not.
Do you have any idea what did or didn't happen inside the Sally Port?
Objection.
Sustained.
You were asked by Mr. Brennan, you could have taken photos had you wanted to, correct?
Correct.
And certainly you could have, right?
Correct.
Was that your vehicle that was being seized?
No.
You were simply there to assist another officer, right?
Objection.
Before Mr. Jackson.
Of course. What were you there to do?
Just to assist another agency.
Would it have been normal protocol for you to photograph that vehicle?
No.
Did you see Trooper Proctor photograph the vehicle?
No.
Did you see Sergeant Buchanan photograph the vehicle?
No.
By the way, you and I did meet once before, correct?
Correct.
Was that before or after you testified last year at another hearing?
After.
And you were called by whom last year at the other hearing? The defense or the Commonwealth?
The Commonwealth.
You testified for them?
Correct.
Objection. Move to strike.
So that's stricken. It's beyond the scope.
Did the Commonwealth ever contact you after your testimony at the hearing last year?
They did not.
Did they ever call you on the telephone?
After?
Correct.
No.
Did they ever send you a subpoena?
No.
And you testified last year that the taillight was cracked but not, or damaged but not completely broken, correct?
Objection.
Sustained.
You and I met in a hotel in a conference room, correct?
Correct.
Anything sketchy or nefarious about that?
No.
Did I introduce myself to you?
You did.
You happen to know I live in Los Angeles?
Correct.
I don't have a house, right?
Correct.
I don't have an office out here, correct?
Objection.
Sustained.
Do you know whether or not I have an office?
I do not.
Do you remember me asking you if you would mind meeting at a hotel where I was staying in a conference room?
I do.
Okay. Do you have any problem with that?
Nope.
Did you find that unusual?
No.
Did you and I ever speak, ever, before your testimony last year?
No.
Did I ever tell you how I wanted you to testify?
No.
Did I ever tell you what to say?
No.
Did I show you any testimony?
No.
Did I play you any video?
No.
Did I show you a single photograph?
No.
During that conversation, did you tell me how to subpoena you?
I did.
Did you tell me where the subpoena should be directed?
I did.
Did you tell me your vacation schedule?
I did.
Did you tell me your availability and willingness to testify?
I did.
Did we talk about any other thing of substance other than that and whether or not you recalled what your testimony was from last year?
That was all we talked about.
As you sit here, Sergeant Barrows, do you have any difficulty recalling what the condition of that taillight was on January 29th, 2022, at about 3 or 3:15 in the afternoon when you saw the vehicle? Any
No.
difficulty whatsoever?
No.
You remember the condition of that taillight?
I do.
Was the condition of that taillight the same as the photo that I showed you on my direct examination?
No.
Okay, that's all.
You would agree that your memory has changed since last time you testified in this courthouse.
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dighton on January 29, 2022?
Objection.
I'm going to allow it. It was opened up.
That's not evidence.
It was opened up.
Is it consistent with what you saw on January 29, 2022?
It is.
Thank you.
All right, Sergeant, you are all set, sir.
Thank you.
Quiet, please.
All right, so jurors, I know I need to talk to the lawyers about a couple of things, so this seems like a good spot to just send you home for the day rather than bringing out witnesses. So those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be careful with your social media. Remember, tomorrow's a half a day. We'll finish by 1.
wonderful. Thank you.
All rise for the court, please. And no one to follow me. Jurors next to the court, please be seated.
So there have been some motions, I think, piling up. Two I have not had a chance to read yet, maybe more. Commonwealth's motion for reciprocal discovery, and then the defendant put in writing about the discovery from Aperture. I've not had a chance to read the prosecutor's opposition. I'd like to do all that before I hear you on that. But the only one that I did read is the reciprocal discovery. Ms. Giannetti, are you examining both Brian Loughran and Karina Kolakithis?
Yes, and there are 3 issues that I believe we should dispatch with today.
All right, so why don't you, sure, I have time, I just don't know what you're talking about.
May we approach
Sure.